Hello, everyone. Welcome to the second meeting of this year's Nonprofit Leadership Alliance at Georgia State University. Thank you all for joining us. We certainly have a special guest speaker in the house today. I'll introduce him in just a moment. But first, I'd just like to make a couple of announcements. Coming up on October 23rd, from 10 a.m. until 11:30 a.m., we will be hosting our NLA virtual mini conference. And the theme this year is how to thrive in a multi-generational workplace. It's a wonderful opportunity to learn from industry experts and also to network and to build some of those credentials for your CNP if you are pursuing that certification as well. And this event is sponsored by State Farm. So if you are interested, certainly reach out to us. You can email us and find out more information. If you're not a member of NLA, but you're interested in joining, you can reach out to Darian Vason. Her email address is there on the screen, dvason, V-A-Y-S-O-N, at student.gsu.edu for more information on membership requirements. Additionally, as an NLA member, you are eligible to receive internship matching. A lot of internships are unpaid, and we know that's really challenging, particularly during these times. However, if you go through all of the steps and coordinate with NLA, then you can, if you've got a small stipend, we'll do some matching there. Or if you don't receive a stipend at all, you can get some compensation for your hard work. So certainly be sure to check that out. And you must be conducting your internship as a part of your academic credit, or again, if you're pursuing your nonprofit professional certification. Our guest speaker this afternoon is Mr. Robert Bexley, Esquire. He is a managing partner at Bexley Deloach, LLC, located in Gwinnett County. And today he's going to be discussing with us some of the finer points of nonprofit law and also navigating the challenges legally that we've experienced since the onset of COVID-19. I will let him take it away.
All right. Well, thank you so much for having me. It's a real honor to be giving back to my alma mater. I actually have 2 degrees from Georgia State University. My first degree was, I think it was 2005. I got a bachelor's of business administration from J. Mac Robinson School of Business. And then in 2011, I decided to go back to school and graduated, went back to school in 2008 to law school and graduated in 2011 with my Juris Doctor. And I've been practicing ever since. I knew from the very beginning I wanted to work in the field of business or nonprofits. I'd always been an entrepreneur at heart, but my first couple of years as a lawyer, I worked for the United States Department of Labor as a staff attorney. And then I went out on my own in 2013, started my own firm, practicing small business law, nonprofit law, things like that. And from there, I've just grown my firm. Now it's myself and 2 other partners. We have a small office in Lawrenceville, Georgia here. And part of my primary duties, in addition to a couple of other areas of law, I do some estate planning and probate, but my primary area of expertise is in helping small businesses and nonprofits navigate the very complicated legal environment, doing a lot of formation, contracts, dissolutions, mergers, purchases, trademarks, and things like that. COVID has thrown a monkey wrench into just about every aspect of human existence and the entire world, especially in America, where our challenges of combating this disease are complicated with societal disagreements, scientific disagreements, but primarily political disagreements on how the disease should be best addressed. And putting all of those factors aside, I think at the end of the day, we can only best address this problem on our own with what resources and tools we have at our disposal. As small business owners or the managers of nonprofits, we have additional challenges because we're not only looking out for ourselves, but we're looking out for our staff and our communities and our clientele. Nonprofits are even more vulnerable because when you add on all of the different challenges that COVID presents, now you have the fact that since a lot of people aren't working, donations are down 75% across the board. Most nonprofits are struggling just to make ends meet, the same as most businesses, but I know of a lot of nonprofits that either have closed up shop altogether, or a lot of nonprofits that would have gotten off the ground and were working towards becoming a tax-exempt organization have just decided to put it off for another day. And the communities that they would have been serving, regardless whether maybe it would have been an animal sanctuary or a domestic violence shelter, homeless shelter, anything like that, has now been put on the back burner because the people who would be running those, they have to put food on their own table before they can even put food on another person's table. And as most of y'all either know firsthand or can suspect, running a nonprofit is a largely thankless, brutal living. My former spouse, she worked in nonprofits for her entire life. I've been working with nonprofits for the better part of a decade now, and I volunteered for dozens. And every single person who gets in, nobody goes into a nonprofit to get rich. And if you do, then there's something wrong with you. I always say that there's no money in doing good, but that's not why you do it. Now, the various legal ramifications of a nonprofit parallel largely those of a for-profit business, but there are some additional nuances. The presentation you have there, it's mostly bullet points. I'm not going to be going over everything in detail. However, for those who want to go do a deep dive into it, there's just a lot of information there. At some point, we're going to switch over and look at a very, very new Georgia law that was passed back in August that gives sweeping protections to nonprofits and businesses for the good or bad. So we'll talk about that in a second. I'll address a couple of real life scenarios that have come up, and then we'll open it up for some questions. I would say that part of owning a nonprofit, unlike many for-profit businesses, is because a nonprofit does not have ownership. Because the nonprofit's owned by the public wealth, the public will, and as such, they don't have shareholders, they don't have owners. So they are working on a sort of moral and ethical level to the community. So most nonprofits serve as a sort of, sometimes involuntarily, as a community pillar, as a community leader. And so nonprofits should take a lead and be the spearhead in creating community understanding and advocacy for COVID-19 safety, to set an example for the business community and for the community as a whole. So making sure that your nonprofit is running safely and observing all of the CDC guidelines and community guidelines that we all have come to expect. Failing those things, you don't set a good example of what a responsible, healthy member of the community should look like. And I think that does a disservice to the nonprofit itself. And that would extend to churches, all the way down to small nonprofits that are running behind the scenes. Then you get into a lot of nonprofits, obviously, like small businesses, have employees. Maybe they have less now than when they started, but they still often do have one or two employees on staff at any given time. The risks of employees with COVID is not as grave as most businesses would have it seem. If an employee catches COVID and it can be shown that they caught it on the job, by and large, it'll be covered by workers' compensation. And so long as you have your workers' compensation policy in place, you should be fine. That should cover it. Of course, nonprofits like for-profits are covered under Georgia's requirements, which is if you have more than greater than 2 full-time employees, you need to have workers' comp insurance. So in businesses that have 3 full-time employees or 3 full-time equivalents, I mean 6 part-timers, for instance, they need to have workers' comp. That is going to be the greatest protection towards your employees. Because if they get COVID on the job, well, that's going to protect you. This law we're about to go over in a second does not protect employees, just the public. You need to get caught up on your Family Emergency Leave Act, if that would be covering your nonprofit or your church. Any sort of emergency paid sick leave. If somebody has to be out because of COVID, there are certain new laws that are going to protect you on there. So being aware of those laws and how they apply to you is very important. Reduce liability. Even with this new law coming out, it may protect you to an extent, but there are always nuances, or it always might be it's yet to be subjected to any sort of judicial review for that all laws eventually get put up against. So you should still be careful and don't get cavalier about your employment policies. Event planning. This is a huge issue right now with nonprofits. I have one of my best friends is an event planner specifically for nonprofit organizations. And until last month, she thought they were going out of business. And then it started picking up again. All the businesses that would have had spring and summer events are now starting to have fall events. And so everything has just kind of shifted 6 months. But it's still put a huge damper on how nonprofits generate revenue. Many nonprofits, so probably over the vast majority of them, use event planning in some capacity to generate revenue, whether it's through silent auctions or galas, even down to like raffles, bingo nights, and things like that. So nonprofits are starting to dip their toes back into the water of event planning, but on a largely scaled back way. You're still having a lot of hotels and restaurants are not opening up for these sort of things. So you have to get creative, going into parking lots, fields. Like, for instance, the Gwinnett County Fairgrounds might be an option for some of the larger events. A lot of churches have large open areas that they normally would have weddings at that might be leasing their spaces out now for events. And you're going to need more space when you're trying to socially distance at these things. You still want people to come out, but you're going to just need larger spaces for people to mingle at a distance. It's important to notify all those involved, participants, panelists, donors, sponsors, caterers, all the people that go into making an event succeed need to be aware of the risks involved. And the organizer of that, whether it's the nonprofit itself or event specialists that they hire, need to be aware of all the different local, state, and federal regulations that control how people are able to get together now, and making sure that these events aren't high risk. So certain events are just going to be very problematic from the get-go. An event, for instance, that is for, say, older individuals, say for nursing homes or nonprofit nursing home, or Alzheimer's awareness, or maybe events that would focus on certain types of respiratory illness, fibromyalgia, or things like that. they need to be more careful, because a lot of the people involved in those things might fall into the category of the people who would ordinarily be helped, and they're going to want to stay away from these events. And so they just need to be more creative and more careful. So being aware of who your participants are and who your sponsors are and how people are able to interact. You don't want to cause more issues because you're just simply you're not cognizant of all the moving parts. Contractual obligations right now are very, very complicated. Caterers, hotels, I see this a lot actually right now is with weddings, which is not what we're covering, but it's overlapping in the Venn diagram. The force majeure, which is also known as, say, an act of God or impossibility of performance, is a very, very hot topic right now in contract law. And there's some competing perspectives on how COVID is affecting impossibility of performance. So just be very cognizant of any contracts you sign that have force majeure clauses or impossibility of performance clauses, and see if there's any escape hatches in case there's a second wave or additional lockdowns. You don't want to be stuck with making a large down payment on a event, on a venue or a caterer, only to find out later that your deposit is forfeit, even without any recourse. Always have contingency plans. Always look for other options, and communicate your decisions to all people. Don't hide the ball. There's no good in that. Liability. This is probably the most common question I've gotten is, what is my liability of X? What happens if somebody contracts this? And honestly, until this law passed, I made a little bit of money just drafting COVID waivers for independent contractors and employees and for participants, not just for nonprofits, but for customers and clients. So the Georgia General Assembly back in August passed OCGA 51-16-1, which is a fancy way of saying the Pandemic Business Safety Act. I think that's what it's called, but it's called COVID-19 Pandemic Business Safety is the name of Chapter 15 of Title 51. Title 51 is actually the torts title, which is covers civil liability, like negligence. So if you get rear-end somebody or somebody defames you, that's the title of the Georgia Code that covers that. So it's very short section. It really only covers 5 areas. And the first one, the longest section, is just really goes over the definitions of what is a claimant, what is the definition of COVID-19. This is typical legal and political mumbo jumbo here, but it defines all the terms that the law is going to discuss. The meat of this code section is found in section 3, 51-16-3. And it basically states that except for gross negligence, which basically means you have done something virtually intentional to harm your clients, willful or wanton misconduct or reckless infliction of harm, you are a business or a nonprofit would be protected from liability claims due to COVID-19 against an individual entity for transmission, infection, exposure, or potential exposure of COVID-19 to a claimant on the premises of such individual entity. And basically, unless they can prove that you have somehow acted in such a gross negligent way as to cause people to get it by coming to your business, which I don't even see how it would rise to that level. You would have to literally walk around coughing on people when you know you have COVID to meet these standards. And I'm not actually even exaggerating there. We're not even talking about not having masks, although, again, hasn't been tested. So maybe not wearing a mask would be considered gross negligence. It's hard to say. Nobody's taken this up the food chain to the Court of Appeals and the Supreme Court. But the biggest thing is to earn the protection of this law. You have to go down to section A2, and it says exactly what you need to do. Is place that warning. It says, warning, under Georgia law, there is no liability for an injury or death of an individual entering these premises if such injury or death results from the inherent risks of contracting COVID-19. You are assuming this risk by entering these premises. If you put that on a sign in Arial font, the letters are at least 1 inch high, because actually later on tells you that section 4 down talks about what the sign has to look like. Place that on your front, all your entranceways, and it, like a magic spell, you're protected. So that a lot of people are shocked at how easy businesses and nonprofits are getting protection from our General Assembly, basically absolving all businesses of most liability on their premises. But because the law is so new, we don't know the true extent of what it will cover and not cover. What activities are good and what not good. Essentially, this basically turns every business into a bungee cord, like a bungee business. Like when you go bungee jumping, you are assuming the risk of the activity. And so if you hurt yourself while bungee jumping, the court's going to look at you and say, well, you knew you're engaging in risky behavior when you did it, so you assume that risk, and you will probably sign a bunch of waivers saying that when you do it. Well, now just going to Kroger is the equivalent of bungee jumping according to the law, because you are assuming the risk by exiting your home and going into these businesses, and the businesses are putting you on notice that just by coming into their business, it could potentially be a cesspool of disease and death, and you should know better. And that's all they have to do. So that's huge. That's a huge law that's passed. Most businesses, I would imagine, are not aware of that law. I would be seeing a lot more signs on doors if they were, and I'm not seeing those signs on doors. I should make up those signs and put them on my letterhead and sell them for $100 each.
Robert, Robert, may I come in? Because under this chapter 51 is where there's the limited liability for board members, volunteers, and folks with nonprofit organizations. And I think that's more of the umbrella type of thing. And so this would be more specific within that.
Potentially, that what you're talking about is more for individual liability. The vicarious liability for owners and board members and things like that covers whether or not you can sue the individual for the activities of the business, and whether an individual's activities can get transmuted onto the business and vice versa. This would be under the same umbrella of defenses and justifications, but it would be more closely aligned with assumption of the risk types of defenses than for individual board members and things like that, because this protects the business, and if it protects the business, it would protect the board too, unless somebody can prove that some board member or somebody did some overt act to cause an unsafe environment.
Yeah, I can see a question coming up from a board member or a volunteer or somebody related to this. That's why I ask.
Oh, sure. Absolutely. It would certainly serve as an additional layer of protection, to be sure, that not only is the business protected, but then they would have that additional layer of protection under the other section of vicarious liability. So it would be like putting styrofoam on top of a football helmet.
Well, and I think the issue becomes, as you mentioned before, people who get into nonprofits are not doing it for money. However, a lot of the board members who serve on a board do have resources of their own.
Oh,
And
absolutely.
in order to encourage good board members to come, we create that liability for them by virtue of serving.
Oh, without a doubt. And I've drafted so many bylaws in my time, and I've gone to so many board meetings to give assurance to board members that the likelihood of them incurring some level of liability is so remote, it's barely worth concerning yourself over. The laws protect directors and board members even more than the managers themselves. If anything, the officers. Yep. Would be the first in the firing range. But as we all know, in most smaller nonprofits, the officers and the board members are usually one and the same. The people that would be most at risk of any sort of liability, and whether it's from COVID or otherwise, are going to be the active managers, the boots on the ground folks, and that would be the treasurer, the president, those sort of things. So unless a board member honestly is committing some sort of, again, intentional act. The most common is embezzlement. That's I would say 90% of board members that get in any level of trouble, it's going to be because of embezzlement. So unless you can figure out like how to stop accidentally embezzling, most board members would have nothing to worry about. And most of that embezzlement, amazingly, comes from churches. Churches are just fertile, and just religious organizations are fertile grounds for corruption and embezzlement from those who want to take advantage of them, because most people in those organizations are so trusting. They don't have as robust of oversight and background checking as other secular nonprofit organizations.
I think the other most common would be self-dealing, where somebody says, the nonprofit is looking for a new piece of property or whatever, and they got this great place for them, which hasn't been looked at for, used to be a waste dump or whatever, and they can't get rid of it to anybody else, so they're going to deal it to the nonprofit.
Oh, absolutely. And what's ironic about that is that it's so easy to self-deal and get away with it ethically that it beggars belief that anybody would be so stupid as to do it the wrong way. Because if you, a lot of nonprofits work within their own membership to get discounts for things, and because they're always trying to save a buck. So a lot of times a board member, say, owns a car dealership. Well, the nonprofit might be able to get a car for cost. And there's nothing wrong with that, so long as everybody is aware of what's going on. I write contracts and loan agreements all the time for nonprofits for 0% interest, or for at cost services or below cost market price services. And all of it is completely ethical and lawful. But then you have people, that will give a sweet contract to their kid for double market value, and boom, suddenly, breach of fiduciary duty. So a couple other points, and we'll wrap it up because I know we're going a little bit long here, is being sure that you are understand how to deal with external closures. If you have a nonprofit that deals with, say, universities or hospitals, or one of my best clients, my favorite clients, is a supporters group for a major sporting league here in Atlanta. So they're a conglomerate of about 1,500 fans who like to get together and have tailgates and support their team. And they are a very large organization. They have multiple officers and about 1,500 members. They generate a lot of revenue, do a good thing. But the entire point of their organization is to celebrate and experience a sporting event. all of which have shut down for 6 months. So what exactly is their purpose? And so they're having to fundamentally change who they are during this crisis to stay relevant with their membership. And so rolling with the punches is so important. Another really important thing is if you have restricted gifts or designated funds, meaning that if somebody has made a donation, that funding can only be used for a very specific thing, or a gift can only be used for X, is contacting the donor or the whoever gave that gift and see if they can be a little bit more flexible with how that gift or donation is used. Most people are understanding of what's going on right now, but if you use a restricted gift or specific designated funds for something that is what it's not earmarked for, that's a breach of contract case, and that can really get a nonprofit into trouble. Finally, just refocus on your purpose and mission. Just take this time to reevaluate what you can contribute to the community, and to see if you can expand upon your mission a little bit to manage the crisis. Maybe there's more that you could be offering without changing yourself so much that you're going off your exempt purpose, but you can still maybe expand how you help people and get creative. Be a beacon of innovation within the nonprofit community instead of one who just simply gives up when a real challenge presents itself. So that's my recommendations. I have one last point on the CARES Act, but that's not as important. It's just some information. But a lot of nonprofits, they face the same liabilities and struggles as for-profit businesses, but at a tenth of the budget and mostly dealing with volunteers. And so it's just, they need to be aware that they are struggling through the same things as businesses, but making sure that they get the best information and not just surfing the internet for solutions. They need to be turning to their experts now just as before. And we're all here, whether it's your insurance agents or accountants or your attorneys, we're all in it with you, and we're here for you.
Well, to the CARES Act, Robert, what about those nonprofits that did take a loan or thing out? The big issue here is, when is that going to be due? Will there be an extension? Will there be some forgiveness? Do you have any sense there?
Yeah, I mean, I myself our firm got an IEDL and a PPP loan grant. Nobody's quite sure what to call it anymore. The EIDL is, and I misspelled the acronym there, my apology. The EIDL will definitely be due, but it'll be due in about a year. And I think it's hovering at about 1.5%. It's just a really low 10 to 15 year loan that will be due in about a year with no interest buildup. The PPP is what's really up in the air, because one of the prevailing solutions that Congress is kicking around with massive support from bank lobbyists is loan forgiveness for anything under, I think the number they're kicking around right now is $150,000. So basically any entity which received $150,000 or less, and that number might even be higher, would essentially, it would be converted into a grant. And so long as you signed a piece of paper saying, like, affirming and swearing that you use the funds appropriately, that's all you would have to prepare and submit. The reason for that is that 70% of the loans out there were small loans and of $150,000 or less, but something like 90% of the money that was given out was for these massive organizations, millions of dollars. So the vast majority of the applications are folks like me getting, just 5 and 6 figures just to keep payroll above board. But the banks don't want to be processing hundreds of thousands of tiny applications when they could just be focusing all their efforts on the big ones. So Congress is probably at some point going to be past turning all those small loans, PPP loans, into grants. Now, even if they don't do that, the timeline is 6 months from the point of when you would have run out of money, which would have been typically after 60 days. So essentially 8 months from when you got your funding, you should be providing documentation to your lender showing how the funds are used and signing off on an affidavit. Honestly, it's like a 3 or 4 page document with a bunch of supporting bank records. So the majority of people, if they were smart, my understanding, who are smart about this, opened up a new bank account only for PPP funds and dumped their PPP funds in there, used it for payroll and healthcare costs and health insurance and their rent and utilities, and did that for 2 months, and then shifted all their expenses back to their old operating account. And then all you have to do is print up your bank statements from 2 months and submit that with a couple of affidavits, and you're done. Honestly, the average business, it should take less than 2 hours to submit their forgiveness documents. But it is essentially 6 months from point of using your funds.
So if that's converted to a grant, if it's for a nonprofit, there is no tax liability, I would assume. But what about the small businesses? If it's converted to a grant, would they have to show that as income?
I'm not a tax attorney, but if I were, I'm a hope for the best, prepare for the worst kind of guy. Probably not. I would probably say that they would embed language with whatever part of the amendment to the Act, the CARES Act, that would convert it to a grant. The likelihood of that being exempt from tax liability is very high, because it would just be a slap in the face to everybody who took that out, to convert it then into an income tax, because then you get a $50,000 grant and suddenly you have to pay $15,000 on and taxes on it. Well, hell, should have just given me $35,000 and called it a day. So they'll probably give a tax exemption on that amount of money for any part that was used for the exempt purpose.
Yeah, there's going to be a lot of forgiveness for things in 2020.
Yeah, and some things to forgive and some things you can't forgive. But it is a challenge, and I know a lot of nonprofits got that PPP and the EIDL, and they really used it to stay afloat. I know I can say right now, had we not received them, my firm probably would have gone under. Our revenue was down 70%. I knew nonprofits that couldn't even operate for 3 or 4 months. They just went away. But now people are creeping out. I think winter is going to be the new spring for businesses, so long as we don't have a second wave of shutdowns. I think we can see the light at the end of the tunnel with that big, qualifier.
I'm curious, and that was great. That was really, really informative. You mentioned that there were few folks who were kind of, frankly, in a position similar to mine, approaching that time in which they will, officially launch their nonprofit and begin accepting donations, and they maybe just secured 501c3 status, and then they've had to either completely discard their plans or put them on hold. I'm curious to know what advice you might have, for someone who finds themselves in a similar position. Perhaps they have, the folks who've invested, that provided some upfront costs, or who have otherwise assisted in this process, and now they're facing a challenge. What are some legal things that they need to be aware of before deciding to dissolve? Or what are some alternatives they can consider if they choose not to go that route?
Absolutely. I've got a couple of clients. For instance, one client got halfway through the process. She had us form the nonprofit corporation. We got the notice filed. We got the bylaws written, everything like that. And it comes to now setting up her 501c3. So what we did was we bifurcated the attorney's fees, and we're like, okay, pay half for the formation of the business, and when you're ready, come in, pay for the other half to get your 501c3 status. And she just kind of ran out of money, and now we're working with her. But I think she's now in this gray area because she's a nonprofit corporation, but she doesn't have tax exempt status. So any revenue she generates right now is going to be taxable. People conflate nonprofit corporation with tax exemption, and that's a flawed logic. And we've tried to make sure she's well aware. It's like, if you can scratch together a few bucks to get the 501c3 status upgraded, you're eligible. Just we'll work with you. And I have another client who got through all that. We had her on a payment plan. She actually this month will be finally paying it off after 4 or 5 months. She's running a goat sanctuary out in the country, and wonderful, wonderful people. And they're building a barn. Well, they can't build the barn because they're very susceptible to the COVID health issues. And so what they're doing, I think this is smart, is that until they can really feel comfortable getting people out there, volunteers, to start do a barn raising, they're just taking in donations. So every Friday they do a silent auction. Every Friday they get somebody to donate a piece of art, or a signed book, or a piece of jewelry that they've created. They've reached out into the artistic community to donate these objects, and they're doing online silent auctions. So they do it on Facebook. So they're basically getting people to commit to doing these things, and they'll have like, okay, today is the day. If you're going to donate $5, do it today. Instead of going out and get Starbucks, can you give us $5? And they're being very creative with fundraising at a distance with just micro donations. And I don't really know how much they've built up, but they say if business is down, market. You should never be doing nothing. And that's what I advise right now. If you're not able to work at your fullest potential, go ahead and get that 501c3 status. There's no downside to just sitting there with a unsown field, a fallow field, because it's not like you're going to be billed for existing other than your $30 annual registration fee. Keep it open. Don't dissolve. Wait to see what's going on. Have your annual meetings or your quarterly meetings on Zoom and just talk about what the future is going to look like. Keep existing. Nonprofits are in the unique positions opposed to a for-profit business, and they can just sort of exist by not existing. So take advantage of that opportunity to just market, to keep awareness alive, to pre-plan, and then when spring comes around, or maybe even in summer, is that you're able to hit the ground running, energized, enthusiastic, with hopefully upwards to a year's worth of planning ahead of you, where you should just be able to rock it because you know exactly what you're going to do and how you're going to do it. And by that time, people are going to want to give. They're going to want to be out there. They're going to want to mingle and socialize and do cool activities. And those who have taken this time wisely to plan for those things, to get creative, and to tap into their communities and to keep interest alive through new technology and social media, are going to be the ones that are going to survive this and thrive when this is all over.
Good advice.
Yep.
I agree. Thank you. Thank you so much. Well, Mr. Bexley, we appreciate you joining us today. It was
Absolutely.
a pleasure having you, a fellow Panther. So we enjoyed your presentation, and I know that other students will benefit from the knowledge that you had to share. Just to close out, let's see. And if someone is interested in getting in touch with you, I don't know if you offer internships or if there's if you ever conduct any mentorships or anything with students. But if someone is interested in reaching out to you, what's the best way for them to get in touch?
Absolutely. We're trying to figure out how to do internships and mentorships remotely. Part of the problem with internships is that so much of it is hands-on, having somebody looking over your shoulder and taking care of it in that way. So we're still trying to figure out. We're still trying to figure out how to do social distancing and ourselves. But when the time comes, absolutely. We would love to have interns and people out that want to participate. Also, we have lots of resources. So even if your interest is not with getting with a law firm, but getting in touch with, any sort of amazing nonprofits out there that meet any of 100,000 different interests, we probably know them. We probably have upwards to about 100 separate clients, active clients, and maybe about 300 or 400 over the last 10 years that we can reach out to at any given time and say, hey, here's a person that's really interested in helping out in an animal sanctuary. Here's a person who's really interested in helping out with a homeless shelter, et cetera, et cetera. But they can reach out to me directly at Robert at Bexley, Bexley, Deloach, DELOACH.com. It's Robert at BexleyDeloach.com. Or they can call our office, 770-689-6006, or go check out our website, which is BexleyDeloach.com. We just really could use any good ideas. If you're running if you want to start a nonprofit, we can help you. If you have an existing nonprofit and you need advice, or you want to do something special like doing a trademark, or you just need to have an attorney sit in on a board meeting at some point, you need additional help on an advisory board, give us a holler. I can help you out.
And Robert, I don't know if you know, but Aisha is in a class in the law school that graciously accepted about 10 of our nonprofit study students to be with them. So it's a tremendous learning experience, and I hope that we'll share the tape of this, the record of your conversation with them as well as with our other students.
Absolutely, and if y'all ever need my assistance like this or anything else in the future, don't hesitate to reach out.
Great. Thank you so much.
Thank you guys. I appreciate it. Y'all have